Good morning, everyone. So, in this video, I'll be discussing Title 4 or Crimes Against Public Interest, and it includes Articles 161 to 189. So, the crimes in this title are in the nature of fraud or falsity to the public. The essence of the crimes under this title is that which defraud the public in general. So, there is deceit perpetrated upon the public, and this is the act that is being punished under this title. So, Title 4, some of the crimes here has extraterritorial application. If you remember from our Criminal Law 1, Article 2, that there are crimes that applies even outside of the jurisdiction of the Philippines. So it includes forging or counterfeiting any coin or currency note of the Philippines and obligations and securities issued by the government or of the Philippine Islands. And another is when one should be liable for acts connected with the introduction into the islands of the Philippines and the obligations and securities mentioned in the preceding number. So we go now to the first article. So Article 161 is counterfeiting the Great Seal of the Government of the Philippine Islands and forging the signature or stamp of the Chief Executive. So what are the acts punished here? So first we have forging the Great Seal of the Philippines. Second is we have forging the signature of the Chief Executive or the President. And third is we have forging the stamp of the Chief Executive. So Article 161 punishes the crime that when you forge the seal, when you forge the signature, and when you forge the stamp, the person is the one who committed the forgery. But if the offender is not the one who forges the great seal, the signature, but he knows that the document contained has a forged stamp or the signature of the president, and despite such knowledge that it was forgery, he makes use of the same. Now he is liable under the next article. So we go to Article 162, or using forged signature or counterfeit seal or the stamp. So the elements here is that the Great Seal of the Republic was counterfeited, or the signature or stamp of the chief executive was forged by another person. And second is that the offender knew of the counterfeiting or forgery. And third is that he used the counterfeit seal or forged signature or the stamp. So Article 162 punishes the person who, despite knowledge of the forged signature, stamp, or Great Seal of the Republic, still makes use of the same document. So we have an example. So for example, in an official document, the signature of the president was forged by, let's say, X. Then it was given to Y. So Y knew that it was forgery, but he used the same. So what crime is committed? So X here committed a crime under Article 161, while Y committed a crime under 162. So next we go to Article 163, or making and importing and uttering false coins. So the elements of the crime is that there must be a false or counterfeited coins. The second is that the offender either made, imported, or uttered such coins. Third is that in case of uttering such false or counterfeited coins, he connived with the counterfeiters or importers. So when is this committed? So counterfeiting or imitation of false coins is committed by any person who shall imitate a genuine and authentic coin, making it appear that it is true, genuine, and authentic coin. So pagkokopya ng pera. So the offender copies the peculiar design of the coin and makes a spurious one out of it. So another is importing false coins, which is committed by any person who shall bring into the Philippine Islands or the ports any false and counterfeited coins. It is not necessary for the offender to be liable that he shall circulate the false coins, because there is a third act of uttering false coins. So we go na dun sa uttering nga ng false coins. So it's committed by any person who shall circulate, give way to another, pass from one person to another any counterfeited or false coins. So in case of counterfeited or imitated false coins, it is not necessary that the coins be subject of counterfeiting must be of legal tender, even if the coin is not a gold coin. If the offender copies or imitates or counterfeits the peculiar design of the said coin, he becomes already liable under this article. So we go now to Article 164, or mutilation of coins. So the acts punished here is that mutilating coins of the legal currency, with the further requirement that there must be an intent to damage or defraud another, and importing or uttering such mutilated coins, with the further requirement that there must be connivance with the mutilator or the importer in case of uttering. So mutilation is the act of taking off a part of the metal content by filling it or substituting it for another metal or of inferior quality. So the offender gathers the metal dust that he has taken off from the said coin. While the offender took out a part of the metal coin, he is in effect diminishing the intrinsic value of the said coin. Therefore, would be given the said coin and deceiving others will be a violation of the public interest and the crime will be committed. So we go now to Article 165, or selling of false or mutilated coin without connivance. So the acts punished here is the following. So possession of coin counterfeited or mutilated by another person with intent to utter the same, knowing that that it is false, excuse me, or mutilated. So the elements here is that you are in possession of it with intent to utter and the knowledge. So under the first act, the offender is in possession of the false, mutilated, counterfeited coin. It is another person who can counterfeit the coin. The offender is only in possession of it. But in order for him to be liable, he must have the knowledge that the coin is counterfeited or mutilated, and despite having such knowledge, he has the intent to utter, circulate, pass away, to give away to another the said coin. And second is actually uttering such false or mutilated coin, knowing the same to be false or mutilated. So the elements of the second act is that actually uttering and knowledge. So in the second act, it is the act of actually circulating or uttering the counterfeited coin, despite the knowledge that it is counterfeited or mutilated. So we go now to Article 166, or forging treasury or banknotes or other documents payable to bearer, importing and othering such false or forged notes and documents. So what are the acts punished here? So the acts punished here is that forging or falsification of treasury or banknotes or other documents payable to the bearer. Second is importation of such false or forged obligation or notes. And third is uttering of such false or forged obligations or notes in connivance with the forgers or importers. So dito naman yung parang banknotes, money in paper. So we go now to Article 167, so counterfeiting, importing, and uttering instruments not payable to bearer. So the elements here is that there must be an instrument payable to order or the other document or credit not payable to bearer. Second is that the offender either forged, imported, or uttered such instrument. And third is that in case of uttering, he connived with the forger or importer. So yung video na to, by the way, is more of like my last video, the elements. I'll give examples now, here and now, but not really like my other videos wherein it's shown on the screen because we're really lacking of time and we have to finish all the titles. But I'll try in my next videos to upload again once with examples because I think it's easier to understand. Anyway, we go to Article 168. So, illegal possession and use of false treasury or banknotes and other instruments of credit. So, the elements here is that any treasury or banknote or certificate or other obligation and security payable to bearer, any instrument payable to order, or other document of credit not payable to bearer is forged or falsified by another person. So the second is that the offender knows that any of those instruments is forged or falsified. Third is that he performs any of these acts. So one is using of any such forged or falsified instruments or possessing with intent to use any of such forged or falsified instruments. So an instrument is transferred by mere delivery. So for example, a check payable to cash. So whoever is in possession of the said check can come to the bank, di ba? So it can be transferred by mere delivery. So on the other hand, a check is payable to order where it can be transferred by mere delivery when there is an endorsement coming from the person named or specified in the check. So it is an instrument payable to the order of a specific person or his order. So example, payable to the order of, let's say, Princess. So this cannot be transferred from one person to another without an order coming from Princess. So next we have Article 169, or how forgery is committed. So one is by giving to a treasury or banknote or any instrument payable to bearer or to order mentioned therein the appearance of a true and genuine document. Second is by erasing, substituting, counterfeiting, or altering by any means the figures, letter, words, or sign contained therein. So if what has been falsified is a coin, you call it counterfeiting. If it is a stamp, seal, or signature of the president, you call it forging. If it is treasury or banknotes, it's called forging. So if it is a document, you call it falsification. So ito yung mga differences, di ba? So we go now to falsification. So three articles are included here, Article 170, 171, and 172. So in falsification, to amount to this crime, it is necessary that the writing that is falsified must be a document in the legal sense of the word. So it's capable of making rights or extinguishing an obligation. So therefore, it must be complete in itself so that it would be sufficient in evidence. So falsification of mere forms does not amount to falsification of a public document because the said form is not yet complete in itself. It has no name, so no address, and it's unfilled. So it's not yet falsification. Let me explain further in the next slide. So there are four types of documents which may be falsified. So we have first a public document. So a document which is issued by a notary public or competent public official with the solemnities required by law. Second is an official document. So it's a document issued by a public official in the exercise of his official functions. Third is a commercial document or any document defined and regulated by the Code of Commerce or any other mercantile law. Fourth is private document or a document, a deed, or instrument executed by a private person without the intervention of the notary public of any person legally authorized by which the document some disposition or agreement is proved, evidenced, or set forth. So is a public document distinct from an official document? So all official documents are considered as public documents, but not all public documents are considered as official documents. So before a public document may be considered as an official document, it is necessary that it shall be issued by a public officer in the exercise of his official functions. So there is a law that requires a public officer to issue the said public document, then it becomes an official document. In the case naman of a private document, it's one which has been executed by a private person. So there is no intervention of a public official. Pero sa private document, even though it is executed by a private person without the intervention of notary public or a legally authorized person, it can also become a public document. So that is when a private document is submitted to the public officer and it becomes part of the public record. So the moment the said private document becomes part of the public records, it is now a public document, and when it is issued and it is falsified, what is falsified is a public document and no more a private document. So it is necessary to distinguish the kind of document that is being falsified kasi whether it is a public, an official, a commercial, or a private because iba-iba yung effects nito. So if what has been falsified is a public, official, or commercial document, damage or intent to cause damage to the offended party or to any other person is not an element. On the other hand, if what has been falsified is a private document for the crime to arise, it is necessary that there must be damage or at least intent to cause damage to the private offended party or to any other party. So if what has been falsified is, let's say, public or official document, it is not that necessary nga that there is damage because a public document, an official document, is presumed authentic and legal. It is presumed to be prima facie evidence orally. So yung mga facts doon, evidence na agad. As such, the moment it is falsified, the crime will immediately arise without the need that there must be damage, na kailangan may intent. Because in falsification of a public document, what has been violated is the perversion of truth being solemnized, proclaimed by the said document. Hence, yun na nga. As I said, damage is not an element. So we go on this one by one. So Article 171 is falsification by a public officer, employee, or notary public, or ecclesiastical minister. So the first kind of falsification under Article 171, we have falsification committed by a public officer, employee, or notary public, or ecclesiastical minister. So the elements of the crime is that the offender is, yun na nga, a public officer, employee, notary public, or an ecclesiastical minister. And he takes advantage of this official position. So what is taking advantage of the official position? When he has the duty to make or prepare or to otherwise intervene in the preparation of the document, or he has the official custody of the document, which he then falsifies. So third is that the said offender falsifies the document by committing any of the following modes. So yung mga modes down is the following. So kailangan maalala natin to by heart. So it's by counterfeiting or imitating any handwriting, signature, or rubric, causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate, attributing to persons who have participated in an act or proceeding statement other than those in fact made by them, making untruthful statements in a narration of facts, altering true dates, making an alteration or intercalation in a genuine document which changes its meaning, issuing an authenticated form, a document perpetrating to be a copy of any original document when no such original exists, or including in such a copy of statement contrary to or different from that of a genuine original, and intercalating any instrument or note relative to the issuance thereof in any protocol, registry, or official book. So in case the offender is an ecclesiastical minister, the act of falsification is committed with respect to any record or document of such character that the falsification may affect the civil status of persons. So the offender is a public officer, employee. Pag ito nga, pag any of the public officers mentioned therein siya, for him to be liable under Article 171, it is necessary that the document that he falsified must affect the civil status of the person. So if the document falsified by, let's say, an ecclesiastical minister, hindi mag-affect sa civil status ng persons, then he is not liable for falsification, not under Article 171, but Article 172. So a priest, for example, falsified the communion certificates of one of the students. So the crime committed is falsification under Article 172 and not Article 171, because a certificate of communion will not affect the civil status of the said student. So he takes advantage of his official position, as we said a while ago. It requires that kailangan nga yung offender, he takes advantage of his official position. And yun na nga, lastly, to enumerate further, is that the said offender falsifies the document by committing any of the modes I just mentioned a while ago. So if you will look at Article 171, it does not state the kind of document that has been falsified. It may not be stated because it necessarily follows that the document falsified is a public or official document, because the offender is a public officer or employee or a notary public. Therefore, necessarily, yung document being falsified is a public document or an official document. So this is what I said a while ago. We should remember this. Again, these are the different acts of falsification. So these acts of falsification are also applicable in Article 172. So we go to them one by one kasi kanina I just said them. So we enumerate them. So the first one is by counterfeiting or imitating any handwriting, signature, or rubric. So kanina, we already mentioned what is counterfeiting. So the offender is said to have counterfeited the signature, handwriting, or rubric if he has imitated an official handwriting, signature, or rubric. So there is an original handwriting or signature, and the offender imitated or copied the said original handwriting or signature. So is counterfeiting the same as feigning? Feigning a handwriting, signature, or rubric is not the same as counterfeiting. So when you say feigning, it means nagsisimulate ka lang ng handwriting, ng signature, or rubric. That is making a handwriting, signature, or rubric out of nothing, which does not exist. While it is imaginable, di ba? So yung isa, meron ng kinakopyahan. So the second one is causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. So kumare, a notary public prepared let's say a notary public prepared an extrajudicial settlement of an estate. So in the said extrajudicial settlement, yung heirs they agree na parang ipapartition na lang yung property. So, yung extrajudicial statement, sabi ng notary public, it appeared na lahat ng heirs, lahat ng heirs daw nag-participate, lahat pumirma. But, hindi pala. Hindi pala. Kasi yung ibang heirs, let's say, nasa Singapore, nasa Hong Kong, ganyan. So, is the notary public liable under falsification? Let's say, under this number 2. So, yes, the notary public is liable. Kasi, he made it appear na yung persons have participated in the act or the proceeding when hindi naman talaga sila nag-participate. So he caused it to appear na lahat ng heirs nandun when, let's say, 2 of the heirs are in another country. So he is liable under this act. So third is attributing to persons who have participated in any act or proceeding statement other than those in fact made by them. So under the third act, persons participated in an act or proceeding, they made statements. However, the offender in a document may appear that these persons have made certain statements which were not in fact made by them. So for example, yung konsehal, may pinapasang ordinance. So, nag-vote yung mga konsehal. So, dalawang councilor, hindi sila bumoto. They dissented. So, they just stated that they were voting in the negative, but they did not give any explanation dun sa dissent nila. So, sa minutes, sinabi doon nung secretary na yung two councilors na nag-no, they voted no because sinasabi nila na contrary to law. Pero in fact, wala naman talaga silang sinabing reason kung ba't sila nag-no dun sa ordinance. So, is the said secretary liable for falsification? So the answer here is yes. He is a public officer. He is the one who prepared the minutes for the councilors, for the city council, and made it appear na yung dalawang councilors stated that the ordinance is contrary to law. Pero in fact, wala naman talagang sinabing ganun yung mga konsehal. So, excuse me. Fourth is making untruthful statements excuse me, in a narration of facts. So here, the evidence of this act of falsification requires that the offender makes in a document untruthful statements in a narration of facts. So, dito, the offender makes a document untruthful, pero he has a legal obligation to disclose the truth of facts narrated by him. So the facts narrated by the offender are absolutely false. So the untruthful narration must be such as to affect the integrity of the document and that the offender does so with the intent to injure or prejudice another person. So it is necessary that the intention or of the offender must be to injure another person. So in case of making false statements in a narration of facts, it is necessary that the offender must have the legal obligation to disclose the truth in the said narration of facts. So absence of such obligation, then it cannot be said to be liable for falsification. So fifth is we have altering true dates. So it is necessary that what has been altered must be a true date, and in the alteration of the said date, the document will no longer have any effect. Sixth is making any alteration or intercalation in a genuine document which changes its meaning. So the offender makes an alteration and the offender makes an intercalation in a genuine document which changes its meaning. So yung ano ba alteration? So it changes the document. Intercalation naman, there must be some insertion made in the said document, in a genuine document, that change the meaning of the said document. Seventh is issuing in authentic form a document perpetrating to be a copy of any original document when no such original exists, or including such a copy of a statement contrary or different from that of the genuine or original. So, dalawang acts daw na punished here. So, the first is that the offender issued an authenticated form, a document perpetrating to be an authenticated copy of an original document, pero wala naman talagang ganon. And second is by including such copy a statement contrary to or different from a genuine or original. And lastly is intercalating any instrument or note relative to the issuance thereof in a protocol, registry, or official book. So here, as we said a while ago, yung intercalation nga daw is inserting any instrument or notes na iibahin mo nga yung meaning. So these acts, lahat to, under Article 171, the same is also punished under Article 172. So we go now to Article 172. So in Article 172, it's falsification by private individuals and use of falsified documents. So kung sa 171 is made by public officials, here it's by private individuals. So the elements of the crime is that the offender committed any of the 8 acts we just mentioned, and except paragraph 7. So second is falsification was committed in any private document. Third is falsification caused damage to a third party or was committed with intent to cause damage. So in case of falsification of a public official or commercial document by a private individual, it's just the same as Article 171. They only differ in that in Article 171, the offender is a public officer or employee. But in Article 172, the document falsified is a public official or commercial document, but the offender is a private individual. Even if the offender is a private individual, since the document falsified is a public official, or commercial document, so damage or intent is not an element. So falsification of private document by any person. So the document falsified here naman is a private document. So the offender is any person. He can be a private individual, he can be a private public officer or employee. For as long as a document falsified is a private document, it is necessary that there must be damage caused to a third person or at least the intention to cause damage. So the absence of damage or intent to cause damage, then falsification of a private document will not arise. So we have naman yung use of falsified documents. So one is introducing in a judicial proceeding. So ito na yung ginagamit na yung falsified document. So first, pag in-introduce mo sa judicial proceedings, yung elements nito is that the offender knew that the document was falsified by another person. The falsified document is embraced in Article 171. And the offender introduced said document in evidence in any judicial proceeding. We have to note here that damage is not necessary. So the second is the use in any other transaction. So hindi sa judicial proceedings. So dito naman, the offender knew that the document was falsified by another person still. The falsified document is embraced in Article 171 or paragraph 1 and 2 of Article 172. Then the offender used such document na hindi sa judicial proceedings, and the use of the false document caused damage to another or it was used to cause damage. So note that if the person who used the falsified document is the same person who falsified it, the crime is only falsification and the use of the same is not a separate crime. So to cause damage is not an element nga, but it because it is a judicial proceeding. But if the said falsified document in use in any other transaction, this time damage or intent to cause damage is an element. So Article 173, okay. Ayan. Article 173 is falsification of wireless telegraph and telephone messages. So the punishable acts here is uttering fictitious wireless telegraph or telephone messages, falsifying wireless telegraph or telephone messages. So the offender is an officer or employee of the government or an officer or employee of a private corporation engaged in the service of sending or receiving wireless cable or telephone message, and that the accused commits any of the following. So uttering fictitious wireless cable, telegraph, or telephone message, and falsifying wireless cable, telegraph, or telephone message. So using such falsified message, ano naman yon? So here, the accused knew that the wireless cable, telegraph, or telephone message was falsified by any of the persons specified in the first paragraph of Article 173. So yung pangalawa naman is that the accused used such falsified dispatch and that the use of such falsified dispatch resulted in the prejudice of a third party or that the use thereof was with intent to cause such prejudice. So if the act punished is uttering fictitious wireless telegraph or telephone messages and falsifying wireless telegraph or telephone messages, note that this can only be committed by any person working in a department, agency, or corporation which is engaged in the business of receiving and sending wireless telegraph and telephone messages. So under the third act, using falsified wireless telegraph or telephone messages, this time it can be committed by any person. So yung next articles 174 and 175, refer to the persons who shall be criminally liable in case of falsified documents pa rin. So we go now. So Article 174 is false medical certificates, false certificates of merit or service, etc. So liable din pala dito yung, for example, nung high school or nung college, false yung medical certificate mo because you were just absent because you didn't wake up for class. So kawawa naman yung doctors kasi they can be liable under here. under this crime. So under Article 174, if the offender is a physician or surgeon who issues a false medical certificate in practice of his profession, he becomes liable under Article 174. Likewise, Article 174 punishes a public officer who issues a false certificate of merit, service, or good conduct, or um, certificate of good moral character. And Article 174, any private individual who falsifies a medical certificate or certificate of merit or service or good conduct shall also be criminally liable, hindi lang yung physician or yung public officer. So the offender is the person who falsifies, issues the false medical certificate or certificate of merit if the offender is not the falsifier, but he knows that the said document is falsified and he makes use of the same. His liability is under Article 175. So, here naman, ito naman, ikaw naman yung estudyante na humingi ng false na certificate. So, dito ka naman liable. So, under Article 175 is using false certificate. So, the elements of the crime here is that the certificate was falsified by a person mentioned in Article 174. So, yung physician, yung surgeon, public officer, private person. And the offender knew that the certificate was false. And the offender used this certificate. So under Article 175, the offender knows that the medical certificate or certificate of merit has been falsified, and despite that knowledge, he makes use of the same. So we go now to Article 176, or manufacturing or possession of instruments or implements for falsification. So this is the felony that is a person was found in a possession of unfilled out forms of driver's license. So he can be liable for falsification of a public document and liable in Article 176. So under Article 176, what is being punished is that making or introducing into the Philippines any stamps, dies, marks, or other instruments or implements for counterfeiting or falsification, possessing with intent to use the instrument or implements for counterfeiting or falsification made in or introduced into the Philippines by another person. So it punishes not only casual but constructive possession. So a person who manufactured a seal in imitation of the seal of Lipa, Batangas, for example, for making false certificates for the transfer of livestock is guilty of making instrument for falsification of certificates. So a person who possessed an iron brand to be used in falsifying the official brand of a municipality for cattle branding is guilty of illegal possession of an instrument for falsification. So Article 177 is usurpation of authority or official functions. So there are two punishable acts here. So first is usurpation of authority is committed when a person knowingly and falsely represents himself to be an officer or agent of any department of the Philippine government or agency thereof, or of a foreign government. The crime will immediately arise from the mere act of the person of knowingly and falsely representing himself to be an officer or agent of any department or agency of the Philippines or of a foreign country. It is not necessary for the offender to commit any act, to perform any act. It suffices that he falsely represents himself to be an officer or agent of the Philippine government. The crime will immediately arise. So, however, the said false representation, aside from being done knowingly, must be such that he intended to be known by such other person or by public as a representative or of the agent or of the Philippine government. So the second is usurpation of official function. So there is usurpation of official functions. If any person performs an act pertaining to a person in authority or a public officer of the Philippine government or a foreign government or agency, so under the pretense of official function or position and without being lawfully entitled to do so, it is necessary that the offender performs an act. So mere representation will not suffice. It is necessary that he performs an act pertaining to a person in authority or a public officer of any department or agency of the Philippine government or of a foreign government. In usurpation of official functions, it is necessary that the act pertaining to a person in authority or a public officer must be under the pretense of official position and without being lawfully entitled to do so. So 178 is using fictitious name and concealing true name. So punishable din pala to. So it is committed by any person who shall use a name other than his real name publicly for concealing a crime or evade the execution of a judgment or to cause damage to public interest. So yun lang naman, hindi naman yung, let's say, what's this? Yung mga screen name ng mga artista, it's not really included here. It should be committed nga yun ba? Wherein may intent to cause damage to public interest. So the elements of the first act wherein using fictitious name is that the offender uses a name other than his real name, that he uses that fictitious name publicly, that the purpose of the offender is either to conceal a crime or to evade execution of a judgment or to cause damage to public interest. And in the second one naman, or concealing the true name, the elements here is that the offender conceals his true name and all other personal circumstances, that his purpose is only to conceal his identity. So how would you distinguish if the crime committed is using fictitious name or concealing true name? Parang parehas lang naman. So in the crime of fictitious name, the use of a name other than his real name is done publicly. There is the element of publicity. Whereas in the case of concealing true name, it is not necessary that the use of another name, concealing his true and real name, must be done publicly. So using fictitious name and concealing true name differ in purposes. So in case of fictitious name, the purpose is to conceal a crime, evade the execution of judgment, or to cause damage to the public. On the other hand, in concealing true name, the only purpose of the offender is to conceal his true and real identity. 179 is the illegal use of uniforms in insignia. So it's committed by any person who makes use of any insignia, uniform, or dress which pertains to an office not being held by the offender or to a class of person of which he is not a member, and makes use of insignia, uniform, or dress publicly and improperly. Remember, I think in ECQ last year when suddenly all the policemen were wearing what do you call this, yung parang camouflage army print, and I think at some localities they did not allow the wearing of camouflage anymore because it kind of it kind of it kind of relates to this crime. So I think it's very evident then na yun na nga, it's also a crime to dress or to parang represent yourself as being part of that public officer when you're clearly not. So the offender makes use of the insignia, uniform, or dress, and that the insignia, uniform, or dress pertains to an office not being held by the offender or to a class of person which he is not a member. Yun na nga, parang being part of the police or the military, and that the said insignia, uniform, or dress is used publicly and improperly. So the offender uses the insignia, uniform, or dress of an office not being held by him or by a class of a person of which he is not a member. And yun na nga, ginamit niya publicly and improperly. So you can be held liable under Article 179. So we go now to false testimony, or Articles 180, 181, and 182. So false testimony can either be false testimony in criminal cases, so in Articles 182, tsaka Article 181, or false testimony in civil cases, which is in Article 182. So false testimony in criminal cases can either be false testimony against a defendant and false testimony favorable to the defendant. So we go first to Article 181. So false testimony against a defendant. So in criminal proceeding, the offender witness testified falsely against the defendant, knowing that his testimony is false, and then he said that the defendant is either acquitted or convicted. So the elements here is that there be a criminal proceeding, that the offender testifies falsely under oath against the defendant therein, that the offender who gives false testimony knows that it is false, that the defendant against whom the false testimony is given is either acquitted or convicted in a final judgment. While in Article 181, false testimony favorable naman to the defendant, so may criminal proceeding pa rin, that the offender testifies falsely under oath in favor of the defendant. The offender who gives false testimony knows that it is false and that the trial need not be terminated. So in a criminal proceeding, the offender witness testified falsely in favor of the defendant, and he knew that his testimony is indeed false. Whether it be false testimony against or false testimony in favor of a defendant, it is immaterial whether the court will consider or not the said false testimony. The case may be filed already. And lastly, in Article 182, or false testimony in civil cases. So the elements here is that testimony is given in a civil case. So this is when it's ordinary and not special proceedings. So the testimony must relate to the issues presented in the said case. The testimony must be false. False testimony must be given by the defendant, knowing the same to be false. And testimony must be malicious and given with an intent to affect the issues presented in the case. So right after giving of the false testimony, the private complainant or the aggrieved party can immediately file a case against the false witness who testified in favor of the defendant. So, ayun na nga, in case of false testimony in the civil case, right, after the giving of the false testimony, pwede nang ma-prosecute agad yung false witness. In order to amount to false testimony in civil cases, there must be litigation. Take, for example, a sum of money, a breach of contract. If the false testimony is given in a special proceeding, for example, petition for nullity of marriage, petition for separation, petition for habeas corpus, these are special proceedings, and a false testimony of a person who testified falsely during the special proceeding, the case is under Article 183. So, false testimony is in other proceedings na siya. So, false testimony in other cases and perjury in solemn affirmation. So, perjury is the willful and deliberate assertion of falsehood on a material matter made before an officer duly authorized to receive and administer oath. So, the elements of the crime is that the accused made a statement under oath or executed an affidavit upon a material matter. So, there are two ways of committing perjury now. First is that the offender either makes a statement under oath, so he makes the false testimony. Second, he executes an affidavit on a material matter. So, if it is an affidavit, it's also required to be under oath, di ba? So, another element is that the said statement under oath or affidavit was made before a competent officer, duly authorized to receive and administer oath. So, in order to amount perjury, it is necessary that the said oath must be given before an authorized, duly authorized, and received to admit, and duly authorized also to administer it. So otherwise, it cannot be considered perjury because the essence of perjury is violation of the solemnity of the oath. So if the person who received the oath is not duly authorized, it cannot be said that there is violation of the solemnity of the oath. So another element is that in the said statement or affidavit, the offender makes a willful and deliberate assertion of falsehood. So it is necessary for perjury to arise that the offender deliberately, knowingly asserted a falsehood, that there was a deliberate intent on his part. Therefore, good faith is a defense in perjury. So perjury likewise cannot be committed out of mere negligence. It is necessary that there must be deliberate intent on his part to assert a falsity either in the statement or affidavit, that the said statement or affidavit containing falsity is required by law. If it is not required by law, then it cannot be considered a crime. So we have Article 184, or offering false testimony and evidence. So it's committed by any person who shall offer in evidence any false testimony or a false witness, either in a judicial proceeding or in any other official proceeding. So the elements here is that the offender offered in evidence a false witness or false testimony, that the offender knew the witness or the testimony was false, and that the offer was made in a judicial or official proceeding. So, same lang ba to as subordination or of perjury? So, subordination of perjury is committed by any person who procures a false witness in order to perjure himself and testify falsely in a case. So, there is no such crime as subordination of perjury under the present revised penal code because we already have Article 184. Article 184 is committed when any person who procures a witness and offers him as evidence in the court can be held liable. And he can be held liable here as the principal by inducement in the false testimony or a principal by inducement in perjury. Therefore, subordination of perjury is not necessary as it is not a crime under the Philippine jurisdiction. So Article 185 is machinations in public auctions. So there are two acts punishable under Article 185. So one is soliciting gift or promise. So by soliciting any gift or promise as a consideration for refraining from taking part in any public auction, the mere act of soliciting any gift or promise so that he will refrain from taking part of the public auction will already give rise to the crime. It is not necessary that he actually receive the gift. It is not necessary that he will not participate in the said auction. So the elements here is that there was a public auction. Second is that the accused solicited any gift or a promise from any of the bidders, that such gift or promise was the consideration for his refraining from taking part in that public auction. Fourth is that the accused had the intent to cause the reduction of the price of the thing auctioned. So the second act is attempting to cause bidders to stay away from the auction by threats, gifts, promises, or any other artifice. So by attempting to cause bidders to stay away from an auction by threats, gifts, promises, or any other artifice, the mere attempt to cause bidders not to participate in the said public auction by threats, gifts, or promise will already give rise to the crime. It is not necessary that the bidders would not actually participate. So the elements here is that there must be a public auction. The accused attempted to cause the bidders to stay away from the public auction. It was done by threats, gifts, promises, or any other artifice, and that the accused had the intent to cause the reduction of the price of the thing auctioned. In order to be liable for this crime, whether it be the act of solicitation or the act of attempting to cause the bidders to stay away from the public auction, it is not necessary that the intention of the offender is to cause the reduction of the price of the thing which is the subject of the public auction. The acts complained of must be done for the purpose of reducing the price of the thing being auctioned. So in public auction, it is necessary that the public must be able to get the best price for the thing being auctioned. If there will be less bidders, less participants in the said public auction, then the public will not be able to get the best price for the thing subject to the public auction. Here, if the non-participation of the other bidders was caused by a person, then he is liable under Article 185. So Article 186 is monopolies and combinations in restraint of trade. So the acts punished here is that the prevention of free combination to competition in the market. So this is committed by any person who shall enter into a contract or agreement or taking part in any combination where in the form of trust or otherwise in restraint or trade or commerce or to be prevented by artificial means free from competition in the market. The second one is monopoly, to restrain free competition in the market. So this is committed by monopolizing any merchandise or object or of trade or commerce or by combining with any other person or persons in order to alter the prices thereof, by spreading false rumors or making use of any other artifice to restrain the competition in the market. And lastly, manufacturer, producer, or processor or importer combining, conspiring, or agreeing with any other person to make transactions prejudicial to lawful commerce or to increase the market price of merchandise. So the first two acts under Article 186 can be committed by any person and not necessarily by manufacturers, producer, or processors. However, yung third act can be committed only by manufacturers, processors, producers, and importers who combined with any other person or persons in order to commit a transaction prejudicial to lawful commerce or to increase the market price of any merchandise or object of commerce. So whether it be the first, second, or third act, then your conspiracy in order to restrain or to prevent the free competition will already give rise to the crime. It is not necessary that there be actual restraint in trade or commerce. So we go to Article 187, or the importation and disposition of falsely marked articles. So it's committed by any person who shall import, sell, or disposes any article or merchandise made of gold, silver, or other precious materials, or other art or their alloys. So here the offender imports, sells, or disposes any article or merchandise made of gold, silver, or other precious materials, or other alloys that the stamps, brands, or marks of those articles or merchandise fail to indicate the actual fitness or quality of said metal or alloys, and that the offender knows that stamps, brands, or marks which fail to indicate the actual fitness or quality of the metals or alloys. So this is considered a criminal act because the offender, despite knowing that the articles or merchandise that he imported are misbranded, he still imports the same and sells the same or disposes the same. So mere importation is a punishable act. Therefore, it is not necessary for the offender to become liable under Article 187 that he must have sold the misbranded articles or that he must have disposed the article, because mere importation will give rise to the crime. So here we have in the screen, sa gold, it's less than 0.5 carats, sa silver, less than 0.004, and flatware made of gold less by more than 0.003. So Article 188 is substituting and altering trademarks, trade names, or service marks. So infringement is the use of another's registered trademark or trade name. So the acts punished here is that substituting the trade name or trademark of some other manufacturer or dealer or to colorable imitation thereof for the trade name or trademark of the real manufacturer or dealer upon any article or commerce, and selling the same, selling and or offering for sale such articles of commerce, knowing that the trade name or trademark has been fraudulently used, using or substituting the service mark or some other person or to colorable imitation of such mark in the sale and advertising of services. And lastly, printing or what's this? Printing or lithographing or reproducing trade name, trademark, or service mark of one person or a colorable imitation to enable another person to fraudulently use the same, knowing that the fraudulent purpose for which it is to be used. So last article is unfair competition, fraudulent registration of trademark, trade name, or service mark, fraudulent designation of origin, and false description. So the acts punished here is unfair competition. So it's selling goods, giving them to general appearance of goods of another manufacturer or dealer. So sale of goods similar enough to cause confusion in the minds of the general public, whether certain goods have been clothed with an appearance which is likely to deceive the ordinary purchaser, exercising ordinary care, and not whether a certain limited class of purchasers with special knowledge, not possessed by ordinary purchaser, could avoid mistake by the exercise of this special knowledge. So second is fraudulent description or origin of false description. Third is affixing to his goods or using in connection with his services a false designation of origin or any false description or representation. Fourth is selling such goods or services. Fifth is fraudulent registration. So procuring fraudulently from the patent office the registration of a trade name, trademark, or service mark. So what do we mean by unfair competition? So it consists in employing deception or any other means contrary to good faith, which shall pass off the goods manufactured by him in which he deals, or the business's services for those of the one having established such goodwill, or who shall commit any acts calculated to produce such result. So mark is any visible sign capable of distinguishing the goods or services of an enterprise and shall include a stamped or marked container. So, trademark naman is the name or designation identifying or distinguishing the enterprise. So, the elements of unfair competition is confusing similarly in the general appearance of the goods and intent to deceive the public and defraud the competitor, while the elements of trademark infringement is that the validity of the plaintiff's mark. Second is that the trademark or trade name must not be merely descriptive or generic, and the plaintiff's ownership of the mark and the use of the mark or its colorable imitation by the alleged infringer results in the likelihood of confusion. So, thank you for listening. That was Title 4 of the Revised Penal Code Book 2. Hopefully, I'll be uploading until Title 7 because I already uploaded from Title 8 to Title 14, I think. So I hope we finish all of our criminal law lectures. Thank you for listening. I hope it helps your review in criminal law too. Thank you.